Mining Company has been ordered to stop drilling on the traditional land of the Wahgoshig First Nation. The injunction against Solid Gold Corp was handed down today. It was brought by the First Nation who says the company is trespassing. Kate Kempton is the lawyer for the Wahgoshig First Nation, and she joins us from Toronto. Thank you so much for joining us today. Now, what is the issue that the Wahgoshig First Nation has with the Solid Gold Corp?
The Solid Gold came onto Wahgoshig First Nations traditional territory without any consultation or accommodation at all, and started drilling and engaging in other exploration activities on land that is of sacred value to the First Nation. It is known to have high cultural heritage potential. There will be burial sites and other cultural heritage sites in the area. It is also an area of extreme importance to Wahgoshig for the exercise of Aboriginal and treaty rights. And without any consultation to let them, the First Nation, know what their plans were and what they were doing, there could obviously be no opportunity to engage in protection and other measures to ensure that their rights, values, and heritage were protected. So yes, Wahgoshig took serious issue with that kind of an approach, which we said, and the judge agreed, is illegal. It's in defiance of their constitutionally protected Aboriginal and treaty rights.
Okay, well, as you said, that the judge released a short ruling today. What exactly did that ruling say?
We sought an injunction to stop any further exploration activity by Solid Gold, and the judge agreed with us. She ordered an injunction to stop any further exploration activity in Solid Gold's claims block for 120 days as of the date of the release of the decision. She ordered that during that time, the Crown, the Ontario government, and Solid Gold had to engage in a meaningful process of consultation and accommodation with Wahgoshig. She ordered that if that process turned out to not be productive, then Wahgoshig could go back to court at the end of that period of time and seek an extension on the injunction. Of course, we all hope that the process will be productive and that Wahgoshig's rights and values and interests will be adequately accommodated.
Okay. Well, you know, we often hear about these disputes between First Nations and mining companies. Does this ruling set a standard or a precedent in these types of cases?
Yes, absolutely. I think it's a really important precedent, and by the way, so does Chief Babin from Wahgoshig, who's thrilled about this decision. It ensures that it's made abundantly clear that exploration companies cannot just come onto the land without having consulted and accommodated first, and the Crown also has to consult and accommodate. Solid Gold's argument in this case was that the Mining Act provides for a free entry system, doesn't require permits for exploration per se, and as a result they said we can just basically go on the land and do whatever we're going to do in terms of exploration, and we don't need to consult and accommodate first. And the judge clearly in this case said, no, that's wrong. You do need to consult and accommodate first before any such exploration activity starts.
Okay. Well, what's next for the community? What are the next steps?
Well, I guess we'll have to be in touch with the other parties to this case, the Ontario government and Solid Gold Resources Corp, because the judge did order consultation and accommodation, so we'll have to be in touch with them to attempt to set up some process that is reasonable. We will have to discuss legal costs for this case to date and going forward to see if we can reach an agreement on that, because if not, the judge said she will take written submissions on who should pay which costs.
Okay.
We will, I guess, have to wait and see if Solid Gold is going to seek to appeal this decision. We, of course, have no idea at this point.
Okay.
And those are the next steps that we foresee.
All right. Thank you very much for your time today.
All right. Thank you.